Hi, it's Teresa Bastian with Let's Move Austin, and I'm a certified divorce expert. Today I want to talk with you about the potential liabilities in selling a home during a time of divorce. Specifically, there are four main ways to avoid breach of contract when selling the house. So it's important for attorneys and individuals to be aware of the contractual conundrums that divorcing litigants face when selling their property. In every real estate transaction, there are generally two contracts the owners enter into: a listing agreement with the realtor and their brokerage, and a purchase agreement with the buyers. Each contract comes with its own terms and timelines, and while we could practically write a book on this issue, I'll get straight to the four most common issues for you. This is what you need to be aware of when advising clients, drafting agreements, or requesting orders. Number one, disclosures. Upon acceptance of any offer, a seller must provide a buyer with known material facts, disclosures, within a certain time frame, usually 2 days or less. This boils down to paperwork that needs to be filled out, and if one party does not comply within the specified time period, the sellers can be in breach of contract or give the buyers inopportune advantage in the contract. Point two, inspections and appraisals. A seller has a contractual duty to make the house available for inspections, including appraisals. After all, buyers have a right to inspect the property, and a loan almost always requires an appraisal. If the seller does not allow access to the property within the contractual time frame, this can put them in breach of contract. Number three, personal property. The house, upon closing, must be delivered to the buyer free and clear of personal property unless there's been an agreement to the contrary. So if the party occupying the house simply packs up their stuff and moves out, and the spouse that doesn't occupy the property doesn't have a chance to retrieve their possessions prior to the buyer's closing, both sellers can be in breach of contract. And occupancy, the fourth point. There is a clear date and time the possession is turned over to the buyer. Our clients simply think sometimes they can notify the buyers that they'll need more time. This is not the case unless the buyers agree to it. Delayed occupancy, even though it may be understandable the sellers need more time, it's just not a unilateral decision, and it can put our clients in breach. What are the damages for breach of contract? Well, it all depends, and it can be significant. Buyers lock in their interest rates for a certain period of time. Should our clients cause delays that cause the buyer to exceed their rate lock, their interest rate increases. Extrapolate that increase over the life of a 30-year loan, we could be talking six figures in possible damages. Buyers have already often made arrangements to move into the property. They've given notice at their current residence or even sold it, depending whether they're a current tenant or homeowner. They'll have movers, contractors, furniture delivery, everything lined up, and may have made various deposits for these things. When there is an even 1 day delay, all of these plans get unraveled and damages ensue. In many cases, could be thousands of dollars. Also, if the seller leaves personal belongings behind, someone has to pay to remove them. It could be hundreds or thousands, depending on what the items are. Contractually, both parties on title are the ones liable. The liability can extend to both of them, even though one party may have been cooperative. Alternatively, if there's only one party on title, that's the party to whom the purchase agreement was entered into, and they will bear all the contractual liability, even if the other spouse is causing them to be in breach. As a certified divorce real estate expert, part of my job is to keep both attorneys informed of the process. If things get to a point where our clients are potentially facing a breach of contract, I will be in communication with you. A lot has to happen in a typical 30 to 45 day closing cycle, and we have very little time to resolve these issues before it comes a liability. So if you see an email from me with urgent in the subject line, now you know why. Also know I put our clients on a timeline from day one, so they will be aware of these deadlines, and I always work to resolve the issues before involving an attorney. I appreciate the opportunity to work with family law attorneys. I look forward to representing your clients in the listing of their properties. I appreciate the opportunity to work with Austin area family law attorneys. I look forward to representing your clients in the smooth listing and sale of their properties as needed. Thank you.